Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, what is the special education complaint resolution process?
When a Connecticut or New York education agency fails to comply with the Individuals with Disabilities Education Act, otherwise known as IDEA, or with a requirement of the Connecticut or New York laws regarding special education, an aggrieved individual or someone acting on his or her behalf, called the complainant, can file a written complaint with the Connecticut State Department of Education or the New York State Education Department. This complaint must be filed within 1 year of the time in which you believe your child's school district violated the law. Such complaints can be regarding disagreements over any matter concerning the identification, evaluation, or placement of a student, or the provision of a free and appropriate public education to a student. Complaints must state how your child's school district is failing to follow the IDEA or applicable Connecticut or New York state law enacted to protect children with disabilities, and recount the facts that form the basis of the complaint. Written complaints may be received by the Department of Education that are also the subject of a special education due process hearing or contain multiple issues, one or more of which may be a part of a due process hearing. However, any special education complaint issues that are also a part of a due process hearing will be set aside and not reviewed until after the conclusion of the due process hearing. Further, if an issue raised in a complaint has been previously decided through a special education due process hearing involving the same complainant and the same education agency, the hearing decision is binding and therefore will not be addressed by way of the special education complaint. However, complaints alleging the failure of an education agency to implement a decision from a special education due process hearing can be reviewed and resolved through this complaint process. Additionally, the complaint resolution process provides an opportunity for a complainant and education agency to voluntarily engage in mediation. Mediation services are available through the Bureau of Special Education to assist a complainant and education agency to reach an agreement. Once the State Department of Education concludes the review of the complaint, the education consultant, who is a member of the Bureau of Special Education, will issue a written final decision within 60 days of your request. In the event that the decision indicates that the education agency has failed to comply with a requirement of the IDEA and or a requirement of the Connecticut or New York laws regarding special education, any corrective actions that must be taken by the education agency in order to achieve compliance with said requirements will usually be included in the decision. The corrective actions shall be appropriate to the needs of your child who is the subject of the complaint and may include compensatory services or monetary reimbursement, and may address, if applicable, the appropriate future provision of services for all children with disabilities who are the responsibility of the education agency. While there is no review or appeal of a written final complaint decision, a parent or a school district may raise the same issues through a due process hearing and or mediation. If you have any questions about the special education complaint process, please feel free to give me a call.